Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Okay, welcome. Today we're going to talk about considerations on capacity issues, mental capacity issues in estate planning and trust and estate litigation. We're talking about the capacity to make a will or a trust, what is required, and I think to some extent we're going to be talking about what exactly is undue influence. And our guest today, as I'm very pleased to have him, is Nicholas Van Brunt, Esquire. Nicholas is a partner with SheppardMullin, Richter and Hampton in Los Angeles, works out of SheppardMullin's Los Angeles office. He focuses his practice on disputes over trusts, estates, conservatorships, and other fiduciary matters. He's a very respected member of the Los Angeles legal community and is known as an effective trust and estate litigator, and one with whom I have worked several times on matters that many would regard as pretty complicated. I think that's a fair statement. Welcome, Nick.
Thanks, Peter. It's really a pleasure to be here. Thanks for having me.
You know, Nick, many issues, the fundamental issues in trust and estate disputes center on whether the testator, the person who makes a will, or a trustor, the settlor, the person who creates a trust, truly has the requisite mental capacity to accomplish that objective, to do the estate plan. And it seems like it's a misconception amongst many folks out there that just because mom or dad or grandmother or grandpa is facing or even struggling with the conditions attendant to the aging process, loss of cognitive abilities, maybe Alzheimer's, maybe they're in a conservatorship, things of that nature, that they may, for these reasons or reasons of a particular diagnosis of a disease state, therefore lack capacity and have thus lost the ability to do the estate plan. And people will say, well, mom's got this or mom's got that. None of what she did is any good. How might you typically commence a discussion with a client, anybody that comes to your office facing an issue of a capacity of an elder who's maybe passed away or is facing it around, or even right now, as the making of a testamentary instrument?
No, it's a great question. So you have to remember, when somebody's coming to your office in that situation, they're in extremis. They're usually upset because of something that's happened with an estate plan. They're upset because someone's taking advantage of their loved one. Maybe they're upset that someone's accusing them of having taken advantage of a loved one, or having procured an estate plan, when someone lacked capacity. And the first thing you have to do is, even as a lawyer, you have to keep those principles in mind, but you have to be sort of just a human being first, which we all
Absolutely.
are, and you need to ask really factual questions, because yes, I mean, absolutely. People say there's absolutely no way that grandma had the ability to sign this because, she couldn't remember what day it was, or didn't remember who the president was. And conversely, you may have somebody says, absolutely, grandma knew what she was doing because she knew who I was and she knew who the president was. And those are facts that are interesting in a determination, but that's not how. That's not going to be determinative either way, right? It's a whole soup, as we'll get into, of facts that determine whether somebody had capacity or not. So the first thing you do is you just try to gather facts and ask questions. You ask, were they evaluated by a doctor? Who were they evaluated by? Do you have the medical records? Do they know who you are? Are they able to speak? Were they able to speak? Were they, did they know what assets they had? You just ask those basic fact questions without trying to lead either way.
Right.
Yeah.
Yeah, and so each situation has to be evaluated on its own facts and merits, and I would imagine included in that conversation would be their personal observations, their contact, kind of a just the facts kind of thing. Where people come, they're upset because of what brother did or what somebody did in the family, and they want to tell you the story, and you want to get that story, but you also want to know. Like they used to say on Dragnet years ago, I'm dating myself, but it's like just the facts, just
Absolutely.
don't color it with what your opinion is. And we want to hear that story too, but we just need to, what is your percipient observations of mom or dad at any time? Because that really goes in our minds as lawyers, what's going to be presented if it gets that far to the trier of fact in court is what you see, not what you heard someone said or what your opinion of what someone did, but what is mom conversing with you? Does mom know who you are when you go visit her? Do you have you maintained a relationship with her? What's going on with these other folks in the whole dynamic, in the family dynamic? And objectively, was she going to the doctor by herself? Was she able to make the decisions of her own care? All of these different things have to come out in the conversation rather than a knee-jerk reaction to, oh, mom has this, therefore she can't do that kind of thing.
Right.
That a fair statement, do you think?
Yeah, it's a fair statement. And it's also, and I'm sure we're going to get into this, but there's capacity to do what, right? There's a different threshold, as to the capacity to make an estate plan and to make a simple one versus a complicated one, versus the capacity to manage your own affairs and, write checks and balance your checkbook and you manage your portfolio and that kind of stuff. And there's a whole sliding scale. There's also, decision. Can you make a decision to marry? Those types of cases come up sometimes, right? Can you, make healthcare decisions for yourself? All of that is kind of in the soup, and we'll get into that.
Yeah, you make a really good point, what you just said, because a lot of times people will say, well, they can't do an estate plan. Someone doesn't have the capacity to do an estate plan. I'm going to read some case law points in just a moment here.
Sure.
But one of the things that you touched on, which I think is very astute, is, the question as if someone needs help with managing their finances, well, someone might say, well, she can't even write any checks anymore. She can't even do that. Well, that may be because of a physical limitation. That may be because it's just beyond her to beyond an individual at an advanced age to grapple with managing, paying the bills and that sort of thing. It's just beyond them because of, they're having difficulties, getting through their day. But it doesn't necessarily at all affect the singular decision of what I want to do with my money and my funds after I'm passed, because that's a focused kind of decision, and you're not going to be wrestling with that every day, right? You just need to come up for air long enough to know what you want to do with your estate plan, know the natural objects of your bounty, and the size and scope of your estate. And I'm going to ask you some questions about that from your experience in a minute, but I'd like to read some passages from case law and get some thoughts on your thoughts on that. And the reason is because we're faced with issues as lawyers, and with every issue there's a rule, and some of the rules are, kind of astonishing to people when you read them. And I'm reading from Anderson v. Hunt. For the lawyers out there, that's 2011 case 196 Cal App 4th 722. And in that case, it's a pretty important case in what we do. The court reviewed the state of the law as it evolved and still exists, still good law, obviously, and said in a review of a variety of cases that, quote, it is well established that old age or forgetfulness, eccentricities, or mental feebleness or confusion at various times of a party making a will are not enough in themselves to warrant a holding that the testator lacked testamentary capacity. And then there's a bunch of cites going back a bunch of years. And then it goes on. It has been held over and over in this state that old age, feebleness, forgetfulness, filthy personal habits, personal eccentricities, failure to recognize old friends or relatives, that always gets my attention in there, physical disability, absent-mindedness, and mental confusion do not furnish the grounds for holding that a testator lacked testamentary capacity, nor does the mere fact that the testator is under a guardianship or conservatorship support a finding of lack of testamentary capacity without evidence that the incompetence continues at the time of the will's execution. So you read these 1,000 times over. What does all that mean, and how do you relate that to people?
Yeah, and let's start with that last issue, which is from the state of Nelson, right? The idea that in other cases that just because someone's under a conservatorship doesn't mean that they automatically lack capacity. And in fact, in a conservatorship, even someone who is in a restrictive conservatorship with all powers granted, that conservatee retains the ability to make a will. That is one of the very few things that statutorily remains the case. Voting rights, making a will, that stuff is like pretty well protected.
And indeed, isn't it? It's in the Declaration of Rights that you have to serve upon a proposed conservatee if you seek to have a conservatorship, that it says you have the right to do a will or a estate plan. It says a will, it doesn't say a trust, I don't think, but
right. And that's an important distinction that maybe we'll get into. And Anderson, which you read from, also goes to that. But a will is something that cannot be taken away from you as a conservatee. A trust is really kind of a contract between a trustor and a trustee, and the rights to contract can be given to a conservator in lieu of a conservatee. I mean, that happens in most conservatorships, right? So making a trust, and there's a whole procedure that I'm sure will be some other podcast for making a trust in a conservatorship called a substituted judgment proceeding. But the fundamental point is having some agency over the basic decision of who you want to be in charge of your stuff when you die and who you want to have your stuff when you die. The legislature and the courts are really, they're sending a message with all those passages that you just read. They want to protect the rights, our rights, because hopefully, God willing, we're going to live long enough to be in that position one day where, we may want to make changes to our estate plan, and somebody may question whether we can do that. We want to have our rights protected, right? And so I think that's what the courts and the legislature is doing to a point. There is some point, we'll get to that, I'm sure, where, there are plenty of people who lack capacity, and we litigate those cases all the time. But there is a push in statutory authority, in case law, to protect the rights of the testator, or i.e. the person who's died and who has expressed their intent in writing.
And what you've touched upon in conservatorships, while there is a distinction, simple will versus contract, and there's case law that says you lose the ability to contract when you're in conservatorship. There's some line of cases with respect to that, but there's also been evolving things in conservatorships about how many rights you have or what you should have here in the state of California because of recent celebrated cases. That's probably another podcast all of itself. But the thing that always gets to me is when you're talking about there's two cornerstone issues for capacity, specifically when you're talking about making a will. Let's just start with a will. The natural objects of your bounty. Okay, so you know who your family is or who you want to leave your money to. Somebody fails to recognize family members. Well, it says in the case law, I guess you can fail to recognize them some of the time. You just can't fail to recognize them at the moment that you do the will or the trust.
Right. That's a really important. I'm sorry, that's a really important point, and you mentioned that before. I glossed over it. That is fundamental. It's the capacity at the moment that the will was executed that's at issue, right? And capacity can fluctuate. There are good days and bad days. There are good times of the day and bad times of the day, and that's really important.
And I get the recognizing the family part of things. The part I struggle with sometimes is a lot of times people, especially traditionally, I would say, in the affairs of older couples, particularly maybe older moms or moms or grandmothers who maybe, and I want to be very careful when I say this, they might not have had or certain persons might not have supervised the family finances as much as their husband did, and so they know how much they have in a general sense. But if you had to drill down on them as to what they had in a particular sense, because it's being managed, what are the lines there, practically speaking, as to knowing the size and scope of your estate as that second, kind of
right
cornerstone? I guess it's a case by case basis.
It is a case by case basis, but it doesn't mean that you have to have your entire, portfolio memorized. Like if you ask me today, I don't know exactly which funds and in which percentages are in my, 401k, for example, right? I don't know.
Right.
I mean, I have a general sense of how I've decided to invest, in terms of income versus growth. I have a general sense of, what I want to, what I want to have happen in the types of companies I may want to invest in and whatever. But, I don't need to know that level of detail, but I have to have a general sense. I think to have capacity, I have a house, I have money in a bank. It's, somewhere between, $500,000 and $1 million, or 5 million and 10 million even. I mean, that's probably enough,
Right.
I would say, for capacity. And, of course,
for that component of knowing the size and scope of your estate,
Right.
maybe combined with a sense that, you have basic capacity. I know where I am. I know where I live.
Right.
I know I'm in the state of California. I know I have this house. I know that my husband and I bought this house. I know that, maybe you know some details. The mortgage is paid. And I know that my financial advisor has a platform at Charles Schwab and he manages everything. That's probably enough to meet that part, you would think.
Right. And it doesn't even have to be as expressed with it could be expressed with a fraction of the sophistication that you just used to describe that, right? It could be like, I know my, investments are managed with Joe at Morgan Stanley. And I know that, we have this house and my address is X or, X in Palm Springs. And I know that, Bob, my husband, and I own it. You don't necessarily need to know that you own it in joint tenancy or community property with right of survivorship or tenancy in common. I think if you have that basic idea, you can then have the ability to make a simple will, right? To make a simple will. Like I want Junior and daughter to split my estate 50-50, or I want daughter to get more because she's taking care of me, so 75-25, or I want her to get $100,000. You can make that kind of decision, I think, with that little sophistication, I would say, all else being equal, around an estate. But I will also say that if you've got an estate with complicated tax issues, or you're doing generation skipping trusts, or you're doing all sorts of other complicated estate planning vehicles, you're going to need to have a little more sophistication to understand what you're doing there.
Well, and that gets into the whole difference between like what we were talking about, the capacity, the preserved capacity. And I think in California, this is where we get as close to a live free or die kind of. I use that for lack of a better term. It's a description that says, look, we want to. The courts in the state of California, and I think most judges, in my experience, especially on capacity issues, they don't want to deprive a person of deciding what they want to get to do with their own money that they worked for their whole lives with their spouse, whatever. As long as they know natural objects of their bounty, like in other words, if you know who your family member is, you might not like all of them. You might be disappointed in someone, but you know who they are. You're not clueless about who your family members are, and you're not starting to appreciate that somebody who's not your family member is a family member, which could be
Right.
the red flag. That component seems easier to me than the understanding the estate component. But I think you explained it very well, that it's not a, we're not going to micromanage. It's not, right down to the details of how many stock picks you have. It's an overall understanding and appreciation of the estate. Those two things, you get to do a will. With those two things, do you get to do a trust?
Right.
What's the difference, and how might you explain that to a person who comes to see you?
So you're talking about someone after the trust has been done and there's potential litigation.
Well, I'm just saying the capacity. There's different capacity for will and a different capacity for trust.
Yeah, and that goes back to there's this Anderson v. Hunt is sort of the seminal recent case on this, which is this concept of a sliding scale. Some trusts are really simple. So some trusts are simply a living trust that the fundamental difference between the trust and the will is that by putting everything in the trust, you're avoiding going to probate. You're having your family go to probate after you die. And if a trust is simple like that, if it's, quote, more like a will, I think that's literally the language from Anderson v. Hunt, or it's close to that. If it's more like a will, then you need the capacity that's more like the capacity you need to make a will. If it's a more complicated trust, if it's a trust that, again, requires understanding that I need to do this, I'm creating a marital trust so that if I die first, my spouse will be able to have all the income and rights to principal for his or her, health support and maintenance. And they don't need to know that in so many words, but they need to at least know I'm creating something that's going to be held for, my wife or my husband, so that they'll be taken care of. And it's really important that the kids don't get that, because otherwise then there's all sorts of tax problems in about. And I think that requires a lot more sophistication even than just a basic will. So the more complicated the trust, the more capacity you need. I mean, that it's a direct
right. So it's a contractual standard. The way I understand Anderson v. Hunt is that if you're making a change or you're doing something that just changes who gets what, you're at the will standard, even if it's within a trust. If you're doing something that is more complicated, then there's a case like Lintz v. Lintz, and that line of cases that you need more capacity to do those kinds of things. And if you start getting into generation skipping issues or things like that, or you're kicking things down the road, and you got tax issues, or different kinds of specialty provisions in the trust, then it probably takes a little bit more capacity. And there's marriage of Greenway case that actually talks about the whole range of contracts. If you have an executory contract or you're buying annuities, you're doing things of this nature, you need some capacity to understand what's going to happen, when you're going to get your money, what you're forfeiting during your life or whatever. If you're making a will, it's a lot lower. And the lowest form of capacity for any contract is the marriage contract. Anybody can say, I do, right? We're brought up understanding what marriage is about. So the case law really gives us the guideposts on all of these capacity issues. But I've got another question for you here is, the presumption of capacity. What do we mean by presumption of capacity? And is the presumption of capacity also statutory?
Well, yes, but with a caveat. So yes, there is a statutory presumption of capacity, and I think we're talking about, that's probate code sections 810 through 812. We'll talk about that. But and what that means is, again, and this goes back to what I was saying a little bit earlier, fundamentally, we want to treat people like they are capable, right? Now, there is also Civil Code 39, which says that if somebody is substantially unable to manage their affairs, they're presumed, there's a rebuttable presumption that they're not capable, at least of entering into a contract, right? And I've seen that applied in other contexts too. So you have this tension in the law, and just rewinding just for a second, as I was listening to you talk about Lintz v. Lintz and Marriage of Greenway and, all the different standards, all these cases create sort of a mosaic from which you can draw arguments on either side. It's, as Andy Anderson, they said, it's a sliding scale, but it's more of like a three-dimensional like sphere. Right. I mean, it really depends on what's going on. And so that's why, I'm sure it can be frustrating for clients sometimes when they come to a lawyer who at least is being intellectually honest about it, because the answer is like, maybe there was no capacity, or maybe there was capacity, but I need to know more, And so, but that's the reality, because each case is different. But going back to generally speaking, yes, in estate planning, there is a presumption of capacity that, needs to be overcome by the contestant. Generally.
Right. And what you're saying is very true. And the way when you opened it about how you broach these topics with someone coming for the first time, because people are looking reasonably so. They're coming to a law office. They're looking for the bright line rules. And it's the sense that, no, this can't be so because of all of the problems that they had or the struggles that they had both physically and mentally. And you have to take them through this and understand that, look, we have to look at all the facts at all the times. And if a person went in and with a competent lawyer sat down and maybe had 3 sessions or a couple of sessions, whatever, and they were able to articulate what they wanted to do, notwithstanding everything else that they had, and certainly it's a little easier with a will than it would be with a more complicated trust, that testimony of that attorney is going to probably be given some very great weight. There's case law on that, right. and it's a that singular time out of all of the other problems is if they come up to say what they want to do, they're going to be found to have capacity, and it's going to be the burden of the ordinarily, right? The burden of the challenging party, if there's going to be a challenge, to overcome the presumption. And it's counterintuitive that you look at probate code 811 and they have all these lists of all these deficits, and it goes on and on and on. And it's like, you could have all of these things and still have capacity. I mean, it seems, one of them is hallucinations, delusions. I mean, to me, when you start having hallucinations and delusions, you're probably, you have to have some kind of study as to, or expert opinion, or the treating physicians review the records as to how pervasive was that,
right?
And so, how would you just, if it ever happens, the factors in all those many factors in probate code 811, how do you describe those to a client and discuss those factors?
Yeah, and some of them are pretty easy to understand. Orientation, the time, place, person, and situation. Do you know what time? Did they know what time it is? Do they know where they are? Do they know who you are? Do they know why they are where they are? So if they're in the hospital, do they understand why they're in the hospital? If they're in a memory care facility, do they understand why they're in a memory care facility? Generally speaking, ability to attend and concentrate. A lot of times that will be sort of the peg on the continuum will be the mini mental state exam, or the Montreal cognitive exam. Famously, a former president scored 30 out of 30 on that test and said that, he had astonishing mental acuity as a result. I'm not going to get into anything about that, but just to say, that's the test, right? It's this 30-point test where you have to do things like draw what time it is. It's 3:25. Can you draw that on a clock? Can you spell world backwards? Can you count back from 100 by sevens?
I don't know if I want to take that test.
As I'm saying it, I'm like starting to sweat. But like, no, in all seriousness, that's a test that can sort of go to information processing, that can go to the ability to do immediate recall. Another part of the test is they'll read a list of words, and when they read the list of words, you'll recall it immediately, and then you'll be asked about that same list 5 minutes or 10 minutes later. I can't remember exactly the duration, but so there are tests that are out there that are administered by people qualified to do it. A psychiatrist or medical professional is qualified to do so, that can help to get to some of these points that go to short and long-term memory, ability to understand or communicate with others, even level of arousal and consciousness. Frankly, I mean, so that's one of the things, the tools that are used. And in my experience, and I don't know how you feel about this, Peter, experts will say they don't exclusively rely on that. There's all sorts of other factors when they're testifying in court. But at the end of the day, the number on that test carries a lot of weight.
I think the number on the test carries a lot of weight, and we could go, could be a whole podcast on another issue of the who administered the test and how diligent were you to administer the test. I mean, did you do the test in 15 minutes, or did you do the test really quickly? Was the person not on their best that day because they were sundowning in the afternoon? Were they upset because someone dragged them over there and they clammed up or whatever? I mean, there's a lot of things, and sometimes those factors don't necessarily always materialize in the records, right? But there's nothing is perfect. I mean, you try to have a system. The tests are tools. The tests are designed to give some objective sense to the geriatric psychiatrist or the physician who's giving the test as to a baseline of competency with respect to doing certain things that ordinarily you should be determined to do if you're going to determine to have competence. Although when you get to the drawing and the physical things, there could be some wiggle room for if I've got really bad arthritis or something like that.
Sure.
You might have a little of that. So there are some factors in the statute that, to me, and I'm just throwing this out there because it begs more questions than it answers. Like I say, do you have the ability to reason using abstract concepts? Well, that's a can of worms, right? I guess that you open up. What does that mean? I suppose, but I suppose, to me, if someone's conversational with you about a topic of some nature that's more than just yes or no, if you can carry on a conversation about something, you're probably able to reason using abstract concepts. Do you have any thoughts about that?
I think that's generally true, although I will say that particularly people who are very high functioning in their lifetime, who, in professions where they had to verbalize, not just lawyers, but, business people or doctors and, people who are highly educated, they are able to fake it for a period of time, right? So they can have a normal social conversation where they can draw on concepts that are still up here. But that doesn't mean that they're going to remember what they said 3 minutes later, or, B, that they're able to really process like they were, because these are habitual things, right? They're behaviors that were, part of how they made a livelihood or how they, survived certain situations throughout life. And so I don't know that. Yeah, the answer is yes. I mean, that certainly would be a point towards capacity, but it's not conclusive. And that, by the way, goes to what 811 is all about. It's a list of factors, and they can go either way. Dr. Jim Spar, who helped to craft the legislation, he'll be the first one to tell you, like, this is not, and it says it in the statute, this isn't like a checklist, and you don't add them up and then say capacity or not.
Right.
Each their own factors. So, but you're right. I mean, that's a particularly difficult one that really is often going to require expert testimony, I think, to get that.
I wanted to comment on something that you said about experienced people being able to maybe fake it a little bit. And I won't mention any names, but I had a person that I had the rare opportunity to represent, who was a very gifted actress in her life and beloved, and was just, I had the opportunity to go to some social functions, and there was a sense that you could have that she might have had her best days behind her at a certain point, because she was very advanced in her 90s.
Yeah.
But she still had the chops of being on stage and able to do certain things that were, you wouldn't know, you just wouldn't know, because it just was, her muscle memory was in her mind, and it was she was able to put that out there. And I think sometimes that people can do that. And certainly with people who used to be captains of industry, or I had a circumstance where a guy was, he was a warrior. I mean, he was a World War II veteran, Korea, and then part of Vietnam Special Forces, and he just was able to use that command function to assert himself in a very strong way. But his family was very concerned about his circumstance of being taken advantage of, notwithstanding the shell that he had created and the persona that he had created. And even as he was maybe sliding downhill, he was still able to project, but there were things that weren't there, it wasn't very rock solid. You know what I'm saying?
No.
And so those are, you develop a sensitivity after doing this. You've done this for years. You have to really see the nuances, and maybe that's what Dr. Spar was talking about, right?
I think so. I think that's, I mean, I think those anecdotes demonstrate it very ably. Yeah.
Okay, so we've talked about the scale, and I'm just looking at some of these other factors here. One of the things that I see in probate code 811 is that it says that a deficit in the mental functions that are in the list may be considered only if the deficit by itself or in combination with one or more other mental function deficits significantly impairs the person's ability to understand and appreciate the consequences of his or her actions with regard to the type of act or decision in question, which I think goes to the moment of the transaction type of thing.
It goes to the moment of the transaction, and it actually adds a causal element too, right? Like that one or more of these things caused, an inability to really make a decision at that point in time, right?
Okay.
But it goes to the general theme that we're talking about, which is each case is its own, right? I mean, I hate to keep beating that drum, but that's the fundamental point. Yeah.
I think we've covered a lot of things here. I wanted to see if we had enough time, and I'll just touch on it briefly. The concept of undue influence, where it is, and I'll read something. Again, maybe this is more for the lawyers out there, but I think a lot of folks would be able to appreciate this. That our California Supreme Court has in one case defined undue influence as, quote, pressure brought to bear directly on the testamentary act sufficient to overcome the testator's free will, amounting in effect to coercion, destroying the testator's free agency. And that's Rice v. Clark, 2002, 28 Cal 4th Supreme Court case, 28 Cal 4th, 89, page 89. How does capacity issues and undue influence issues interrelate?
Yeah, I mean that's another concept that's really important to try to parse when you're meeting with a client early on, because somebody may have testamentary capacity, may even have contractual capacity, but still be susceptible to undue influence, to having somebody who's having an outsized ability to substitute their will for the person who's purportedly making the decision. And capacity is a factor in that. Obviously, the more impaired somebody is in terms of their mental function, the easier it is usually to impose your will upon them if you're, a bad actor in that respect. But and it sounds like this is going to be something that'll be a whole other podcast.
I think.
Yeah.
Well, I'll have you. Maybe we can have another conversation. Yeah. I think that we'll probably close with that. I mean, that's undue influence is a whole hours upon hours. We could talk about that, but certainly when you're talking about capacity, a lessening of capacity creates a greater susceptibility. A person could be weakened. They're more inclined to give in. They might be more inclined to not be able to put up any resistance to something. And it's like, just the straw, the feather, that will break the camel's back at a certain point. And obviously, there are also concepts of who is the person who is determined to be the unduly influential person, which is different if there are statutory presumptions against care providers. And, a lot of folks come and say, well, second spouse who is married to someone for 30 years unduly influenced our pops to get stuff that she shouldn't be getting, but that might just be a good marriage. That's just what's happened. So it's relationally based too as to who is the undue influencer, which would be, I think, a topic, another discussion for another day.
Yeah. One little teaser on that is just as the presumptions weigh towards presuming people have capacity, increasingly because we're trying to protect, elders defined as 65 or older, although there are many 65 plus people I know who are completely fine in terms of their functioning. The presumptions on undue influence in the common law and in statutes tend to create a presumption of undue influence. So if there's a confidential relationship and there's an active procurement of the will and an undue benefit, that shifts the burden to the person who benefits from whatever transaction or instrument. That shifts the burden to them to prove that it wasn't undue.
Right. You are 100% right on that. And particularly with respect to real estate transactions where it happens a lot. If you want to leave your property to someone after you die, that's one thing. If you're unduly influencing someone to get their property while they're alive, that's a totally different thing. And it shifts the burden to you. And there's a presumption of fraud, especially if there's no consideration paid. So that's a shocker for a lot of people too. And with that, I want to thank you for speaking with me today. I think we scratched the surface on capacity issues, but
for sure,
your way of articulating them is always informative to me, Nick, and I appreciate it. And we'll see folks next time when we are on our next podcast.
Likewise, Peter. I always enjoy our conversations, whether just the two of us or for the world. So thank you very much for having me.
Thank you.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities with your host, Peter Bochnewich. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.